Our next case is State v. Davis. (12-830), State of Ohio versus Tyran Davis. For the appellant, Mr. Scott.
Madam Chief Justice, and may it please the court, opposing counsel. My name is Terrence Kinsley Scott, and I represent the appellant, Mr. Tyran Davis, and I would like to reserve 3 minutes for rebuttal, if I may, Your Honors. Your Honors, Mr. Davis requested and was entitled to a voluntary manslaughter instruction for both his purposeful murder and felony murder charges. Now, the jury was precluded from considering those inferior degree offenses, and as a result, Mr. Davis was prejudiced. Now, ultimately, the Court of Appeals held that Mr. Davis was not prejudiced because he was acquitted of the top count of purposeful murder, and additionally, the Court of Appeals held that Mr. Davis was not prejudiced because voluntary manslaughter is never an inferior degree offense to felony murder. Now, as it relates to his purposeful murder charge, normally, if you are acquitted of the top count, you would not be prejudiced for a failure to instruct on an inferior degree charge. But under these particular circumstances, given that this case involves purposeful murder and felony murder, these alternative theories or these mirror offenses that simply arose out of the same conduct, an error that would otherwise be harmless carries over and taints both charges because that error severely limits the jury, Your Honors. Now, Mr. Davis was prejudiced because the trial court's failure to give that instruction precluded the jury from considering the inferior degree offenses that most closely fit his facts.
Mr. Davis, Mr. Scott, excuse me, was the jury instructed that each count was to be considered separately?
They were instructed that each count would be considered separately, but they were not instructed that in what order to review those counts.
But they were told that for a lesser included offense, they were first to look at the purposeful murder, and only if they could not come to that conclusion did they go to the next level of the voluntary manslaughter, correct?
Well, the issue is they were not instructed on the inferior degree offenses, so they would have never received that secondary instruction, and that's one of the issues.
You never received the instruction on voluntary manslaughter.
Correct.
Right. What were they instructed on? Felony murder and
purposeful murder.
Purposeful.
Correct.
Okay.
Now,
Mr. Scott, if I'm understanding your argument, your client was found not guilty of murder.
Correct.
The situation arose out of an argument where his girlfriend was punched hard enough to knock her to the ground.
That's correct, Your Honor.
And he shot the aggressor and killed him.
Correct.
10 times. There were 10 bullets, right?
Possibly even 11. Yes,
all right,
Your Honor.
fine. And he was found not guilty of purposely intending to cause the death of another.
Correct.
But he was found guilty of felony murder, presumably causing the death of another while committing felonious assault.
Correct, Your Honor.
Now, you want us to reverse that determination and send it back to see if he can get found guilty of voluntary manslaughter or purposeful murder or felony murder. You want another trial.
A new trial, but that trial would only relate to his felony murder charge. Again, he was acquitted.
Pardon me, please?
That new trial, if this court saw fit to grant that, would only relate to his felony murder charge.
Because he was found or acquitted of the purposeful murder.
Correct.
Well, then, you didn't request in the trial court a voluntary manslaughter as a lesser but included offense of the felony murder, did you?
There was actually a request.
I thought the request was related to the purposeful murder.
No, there was actually, if the court would refer to the January 13, 2011 proposed jury instruction submitted by Mr. Davis, it specifically requested an instruction on both purposeful murder and felony murder. And the court denied both in its colloquy, or its in-camera colloquy with counsel.
So you're saying that the voluntary manslaughter is a lesser included of the felony murder? Is that what you're saying?
That is the argument we're making, yes, Your Honor. And it's our position that the Court of Appeals error in this case was compounded when it concluded that voluntary manslaughter is never an inferior degree offense to felony murder. Now, The problem was the Court of Appeals did not cite to any authority to support that conclusion. Now, the Model Ohio jury instructions, the very instructions that the state has attached to its brief before this court, specifically state that in cases that involve a felony 1 or felony 2 offense of violence, voluntary manslaughter is in fact an inferior degree offense to felony murder.
Well, in order to charge on a lesser but included offense, you must find, and the instruction of the jury goes that you must find, if you can't find all of the elements, then you could consider the other, but those must be originating from the purposeful murder, and they don't really originate, I think was what Justice Lansing was telling you, from the felony murder, do they?
Well, again, the Court of Appeals, the conclusion that it came to regarding whether or not voluntary manslaughter is or is not an inferior degree offense to felony murder is somewhat problematic. And what this court held in Deem is that an offense is an offense of an inferior degree when the indicated offense's elements are identical to or contained within the indicted offense except for one more element.
Thank
now,
you. And the point would be that the elements of felony murder are substantially different from the elements of voluntary manslaughter, are they not?
Well, the way the Court of Appeals laid it out was, and this I'm quoting here, the Court of Appeals held that knowingly causing the death of another is not contained within or identical to proximately causing the death of another by knowingly causing serious physical harm. And my question is, and I guess what everyone's question should be, is how is that any different than knowingly causing the death of another plus provocation? Now, given that reading, the elements of voluntary manslaughter are in fact contained within felony murder predicated on felonious assault. And for this court to hold otherwise would be essentially a return back to this kind of element-to-element analysis this court has since moved away from.
So do we need to revisit Dean in your view if we agree with your position?
I think actually the actual controlling case on this is this court's decision in Evans.
In which?
And I'm sorry, Evans.
Okay.
State v. Evans. Now, the problem that this element-to-element analysis creates is that this court wants to move away from that type of jurisprudence because of these absurd results that it creates. And one that type of analysis would create in this case is this notion that a person could never be provoked into a felonious assault if a death occurs. And that sounds ridiculous because, quite frankly, Your Honor, I believe it is. And that's probably why the Court of Appeals didn't cite to any other cases along this line. Because
was there a self-defense or defense of third-person instruction given to the jury here?
There was not.
Was it requested?
I do not believe it was requested, Your Honor. And given the facts of the case, I'm not sure if it would have been relevant, Your Honor.
Thank you.
If I could, if there are no other questions from the panel, I'd like to reserve.
So essentially, if we boiled it down, you want this court to hold that voluntary manslaughter is a lesser included offense of felony murder. Is that really what you're seeking today?
We're actually seeking two things. That would be a perfect summation of one of the things that we're seeking. Second to that would be that in these cases involving these multiple theories that involve a single crime, acquittal on one of those theories does not preclude a finding of prejudice when a trial court fails to give an instruction of an inferior degree. Because the Court of Appeals essentially held that they were not going to review the provocation issue. They simply held that Mr. Davis was not prejudiced because voluntary manslaughter was never an inferior degree offense. And secondly, he was not prejudiced because he was acquitted of the top count. So again, our position would be twofold. Your summation coupled with what I just laid out in the first proposition, Your Honor. If there are no other questions from the panel, I would like to reserve the remainder of my time. Thank you.
Mr. Cassay?
Chief Justice O'Connor, and may it please the court, Richard Cassay representing the state of Ohio in this case. I think counsel for Mr. Davis came to his ultimate point when he suggested that this court move away from an element-based analysis, specifically on inferior degree offenses. Now, certainly this court has moved away from element-based analysis before, State versus Johnson being the prime example. But here, what Mr. Davis wants this court to do has not been the law. I don't know that it's ever been the law, and it certainly hasn't been the law since State versus Deem.
Counsel, the problem I have with this case is that when I look at it from an objective standpoint, this clearly is a voluntary manslaughter case, is it not?
No, I disagree with that. Now,
what element is missing from voluntary manslaughter in this case?
both of them. We have the requirement of the objective component. We have the requirement of the subjective component. Now, what triggered these 10 or 11 shots was the yell, "Bro, he just hit your baby mama." There's no evidence in this record that Tyran Davis saw Stephen Myers lay a finger on Jasmine Downing.
So you're saying the provocation was not proven?
Your Honor, provocation was not proven because, think about the phrase, "Bro, he just hit your baby mama." Now, against the backdrop that this defendant, there's no evidence that this defendant saw that occur, the shout is not, "He just decked her, he just laid her low, he just took her out."
Well, I'm not sure I understand that argument. I'm not sure I understand that argument. What if he had received a phone call that someone just shot your girlfriend and she is dead, and he races into the house? He saw none of that, but he obviously is under passion. He has been provoked.
Well,
So, counsel, you're saying that hit is not a sufficient provocation word to have triggered this type of a response from Mr. Davis to pump 11 shots into the victim.
yes, it's easy for us now to stand back and say he punched her, because that's what the witnesses at trial testified to. But what Tyran Davis heard was he hit her. Now, that goes to the provocation component, and I think it's lacking. Now, there's a suggestion in Mr. Davis's brief that this court should consider the entire scenario that occurred that night, because it's true, Stephen Myers liked to punch women. He punched more than Jasmine Downing. I forget, I don't have the names on the tip of my tongue, but he was punching and pushing other women that night. But it's clear that whole scenario cannot play into a voluntary manslaughter calculation, because that occurred before Tyran Davis was brought to the scene by the two women, including Jasmine Downing.
But wasn't also what was going on there, based on my reading, is that he showed up at the scene and the victim tried to taunt him into a fight between the two of them, and he just walked away like, "This is stupid. I'm not going to engage in this."
Well, Your Honor, you've anticipated what I was going to say, because once he got there, he engaged Stephen Myers in conversation. Apparently, Stephen Myers had the idea that Tyran Davis was going to shoot him then and there, because he said, "We don't have to shoot me. We'll just fight here in the street." Now,
Well, counsel, that's my question, though. Are you saying there's no provocation, or there's not sufficient
there was not
provocation?
reasonably sufficient provocation to incite,
According to whom?
according to the state's reading of this record. Now,
Is that going to control the question? The
Pardon
state's ruling, will that control this question?
the state does not believe that Tyran Davis was entitled to an instruction on voluntary manslaughter under any circumstances.
That relates to for the purposeful murder or the felony murder. It doesn't matter. In your view, the instruction should not have been given at all.
The instruction could not have been given on felony murder, because it's not an inferior degree offense to felony murder. It is an inferior degree offense to purposeful murder. But
You're saying that voluntary manslaughter is a lesser included?
no, it's not a lesser included offense. It's an offense of an inferior degree.
Okay.
Because as far as purposeful murder is concerned, it is identical to or contained within the definition of purposeful murder, plus having the mitigating circumstances. That is not true with felony murder. Now, apparently the relief requested is we go back for a new trial on felony murder, and if we go back for a new trial on felony murder, that's the only thing this gentleman is entitled to, because voluntary manslaughter does not fit felony murder predicated on felonious assault. And that is so because Tyran Davis was indicted on both subsections of felonious assault. Knowingly causing serious physical harm, 1. 2, knowingly causing physical harm by means of a deadly weapon. Judge Dickinson was right in the opinion. Knowingly causing death is not included in either of those definitions. If you turn that around, they're included within knowingly causing death, but that's not how we look at it. We look at it the other way. Is knowingly causing death included with them? And it isn't. Clearly it isn't.
So if the
Mr.
jury
Kasey.
had convicted this Mr. Davis of purposeful murder and acquitted him of the felony murder, then your argument would be that he may be entitled to a charge on voluntary manslaughter because he may have been acting out of some excitement or rage in response to seeing his mother of his child having been struck.
That would be correct, Justice O'Donnell. If he had been convicted of purposeful murder and, in your question, acquitted of felony murder, and no instruction on voluntary manslaughter had been given, then he has a clean appeal. The trial court abused its discretion because the charge was not given.
Mr. Kasey, to understand, I want to make sure I understand your analysis on the felony murder and the voluntary manslaughter. You're saying it's the predicate offense of the felony murder that we look to determine, to match up the voluntary manslaughter?
I don't think it can be any other way, because in a felony murder situation, that predicate offense is what the state really has to prove. After that, it's simply a matter of proximate causation. Proximate causation is an element, but it's not the type of element where you can put other elements into.
So the commission of the felony is purposeful.
Pardon me?
The commission of the felony is purposeful, and that results in the serious bodily harm or death.
It's knowing. Felonious assault, the mental element is knowingly.
Okay.
So, to get back to the initial question, no, the state does not believe there was any entitlement to an instruction on voluntary manslaughter. No objective component, and clearly no subjective component, which the subjective component looks to this defendant's actual situation, not what the court may think as a matter of law is sufficient provocation. The best evidence of what Tyran Davis's actual condition was, really just about the only evidence, was the testimony that when he either ran, jogged, or walked fast across the street before he shot, he looked like his normal self. Now, I will concede that some people can look like their normal selves and be in a rage, but I think the greater likelihood is that they are not. At a minimum, that evidence is ambiguous, and he has the burden of proof. He has the burden of proof by the preponderance of the evidence. With that type of ambiguity, and in the state's view, the greater likelihood that he was not in a rage, then there's no evidence whatsoever of the subjective component. Tyran Davis had the chance to testify. He was asked, his counsel said he's not going to testify. Trial court asked him directly, is that so? He said, yes, that's correct, I am not going to testify. Then defense counsel puts on this charade of a proffer where he would have testified that he completely lost his mind, he was out of control. Nothing worse could have happened to him, and he just emptied his magazine into Stephen Myers. Clearly, that proffer
Part
is
of
not,
that proffer was going to be, I saw my girlfriend on the ground, or
he saw the punch. He put that in there too.
he was going to say that he saw it.
Yes, of course, because there was no evidence otherwise that he saw.
Okay.
So counsel conveniently put that in there for him. But the point is that that is not evidence, at least I hope it isn't, that type of thing. Where the state doesn't get to cross-examine, but we have this put in, and now we're supposed to get an instruction. I don't think we work like that.
So what are we being asked here to write with regards to this case?
I think you should dismiss it as improvidently granted.
Okay. There's no new law in your... Okay.
Not in my humble opinion. Doesn't mean there isn't, but I don't know what it would be. So to hopefully attempt...
Spoken like a true appellee.
Yes. But getting back, well, I'm not going to get back. Unless there are any further questions, I'm going to conclude.
Good move.
Thank you. Counsel, you've reserved about 6 minutes for your rebuttal.
Thank you, Your Honor.
What law would you like us to write here?
Well, two things, Your Honor. First off, in these cases, again, that involve these multiple theories, that involve a single crime, acquittal on one of those theories does not preclude a finding of prejudice when a trial court fails to give an inferior degree instruction. And second to that...
But in this case, would you agree that the voluntary manslaughter is an offense of a different degree to purposeful murder?
I would disagree with that, Your Honor.
You would disagree. You think it is?
Absolutely, because...
What do you think its relationship is to felony murder?
Well, felony murder essentially gives you causation. Felony murder cannot exist in a vacuum. The predicate offense is the offense, the felonious assault, and it's from that where the mens rea is drawn from. And so much so, that's precisely the analysis that the Court of Appeals did. It's just that the analysis, unfortunately, didn't make much sense from my reading. Now, felony murder is approximately causing the death of another by serious physical harm. That's felony murder. That is completely indistinguishable from the definition of voluntary manslaughter, which is knowingly causing the death of another. So to attempt to try to say that one is somehow different is I don't know, is intellectual acrobatics, Your Honor.
Underlying all of this is a fairness argument, is it not? That if the state, looking at a set of facts, decides, well, we're going to be able to convict this individual of either A or B, one or the other. But you're saying if you look at the entire choices that the prosecution has, a third choice is the one that they did not bring or charge. When you look at what unfolded here,
correct,
and you're saying if you're going to give the jury these two choices, then as a matter of fairness, you should tell the jury that given these facts, it could be A, B, or C.
Or even D, because it's our contention that he was entitled to a voluntary manslaughter instruction as to both his purposeful murder charge as well as his felony murder charge. And that's where the prejudice exists in this case, because the jury was precluded from considering all of the offenses.
Counsel, if the evidence, as believed, is that your client did not see his girlfriend hit, do you still think he was entitled to have the voluntary murder instruction?
Absolutely, Your Honor. And,
why?
And what I would say about that is, I guess throughout history, our notions as to what constitutes provocation continues to evolve. Now, in this case, we have a victim who was at the scene looking for a fight. And when he did not get that fight from Mr. Davis, he decided to take that fight to some young ladies. He was punching the women before Mr. Davis even got to the scene. Right, but he punched Mr. Davis's pregnant girlfriend when Mr. Davis was on the scene, because that punch to his pregnant girlfriend is what directly preceded the shooting. So there was literally a matter of no time between him punching Mr. Davis's pregnant girlfriend and knocking her unconscious. Mr. Davis immediately goes up to Mr. Myers and he shoots him. And I can't really understand how that type of a situation that involves someone knocking out someone's pregnant girlfriend does not... He didn't know that she was knocked out cold, that she was on the ground. There's no testimony to that he was aware of that. Your Honor, there was no testimony that he did not see it. Mr. Davis did not testify. So what we have was the testimony of people who were there, and they basically said that the punch to the pregnant girlfriend directly preceded Mr. Davis's shooting, which was also coupled with the statement by someone in the crowd that he had hit Mr. Davis's pregnant girlfriend. But whether or not Mr. Davis saw it or not, that's actually an unanswered question. Do you think that's irrelevant? I think it's relevant, but I don't think it's crucial to Mr. Davis's position, Your Honor. In much the same analogy that was given about a phone call. That someone's being threatened or someone's being hurt, that the fact that that person's passions are being lifted because of this situation is not changed because he did not see the actual impact. And again, that's a question that has yet to be answered, Your Honor. Counsel, it seems strange that for the defense, you are requesting additional potential crimes that your client could be convicted of. I mean, if you're talking about a situation where the state has not proven its case, isn't it more likely that it's better just to say we're going to concentrate on what has been charged, because if the elements are not there, my client is acquitted, whereas the position you're taking is that with these extra offenses, the possibility is, well, there will be an acquittal on the higher offense, but a potential conviction on the lower offense. Well, if this court were to remand this case for a new trial, the only offense the only two offenses that would be in question again would be this felony murder charge and the voluntary manslaughter charge. He's already been convicted of felony murder, so he's not being put forth at any additional risk if he was to go back for a new trial. But we have to find that. Are you saying that we have to find that voluntary manslaughter is a lesser included of felony murder in order to do that? I would agree that this court would, in order for this court to sustain the second proposition, I do believe that this court would have to find that voluntary manslaughter is an inferior degree offense to felony murder. However, this court could still also remand this case on the first proposition with regard to this lack of prejudice because he was acquitted of the top count. So theoretically, this court could sustain one, if not both of these offenses and remand this case for a new trial, Your Honor. Thank you. We'll take the matter under advisement and you'll be notified of our decision. Thank you.